If that wasn't completely clear, it probably became so 5 years later when the Supreme Court considered a case coming out of Pittsburgh, Pennsylvania, actually involving a challenge to two different religious displays that existed in Pittsburgh, Allegheny County. The first was a display in the Allegheny County Courthouse. I don't know if you can see it very well. I've got a poor picture attached to the appendix of the Supreme Court opinion. But it has a nativity scene in the center on the steps of this courthouse, surrounded by poinsettias. The question was, does that display violate the Establishment Clause? The Supreme Court's answer, 5-4 again, was yes, it does. Okay, now, what caused the different outcome in that case? What caused Justice O'Connor to view this as a violation of the Constitution and the Rhode Island case or not? There were no plastic animals, right? Where are the plastic animals? Where's Santa Claus? Where the carol is? They're not there. So the reasonable observer would look at that religious display and view it as an endorsement of religion. That's her view. Now you might ask, well, how about the poinsettias? They're not necessarily a Christian symbol. Maybe they could save the nativity scene. Pittsburgh argued that, Allegheny County. But she said, no, the poinsettias actually frame the display. Kind of draw your eyes into the center of the display. So it reinforces the religious message as opposed to the dancing plastic elephants that they had for that. Right? So that's the Allegheny County Crace decision. And again, the reasonable observer test is the one that seems to come out of that case, just as a kind of opinion. In that same decision, though, the court went the other way with respect to this other display that was in Pittsburgh. And as you can see here, you've got a 18-foot-high menorah, traditional symbol of Judaism, next to a 45-foot Christmas tree. Now, you might look at those, which, well, if that was a violation of the Constitution, then this probably is too, and you'd be wrong. The court comes out the other way on the menorah. Why does it come out the other way on the menorah? Well, it's a salute to religious liberty. That's what that is. Because you've got the Christmas tree, and you've got the menorah, symbol of Judaism, and people are not, the reasonable observer, just as O'Connor thought, is not going to look at that and think, Jews are running Pittsburgh. Or we want everybody to become Jewish. It's not the likely perception of that. Now, you might think that to really reinforce a salute to religious liberty display, you probably should have had a giant Buddha there as well, or maybe a few other things. But now the court thought that was enough. That having the Christmas tree there sort of offsets the religiousness of the menorah, and it's okay. Some people would suggest Christmas tree is actually a Christian symbol too. It has some origins in Christianity, but it's primarily not viewed as a secular. It's primarily not viewed as a secular. Yeah, I mean, some of these things have multiple religious roots, I think, like Christmas tree. But her overall take on that is people aren't going to look at that and say, we're endorsing Judaism, so therefore it's okay. It's a reasonable observer perception. That's good to me out of her case. So that's where we stood after 1989, with Justice O'Connor being the swing vote in those cases. Takes us up to 2005, and 4 cases get to the Supreme Court involving the Ten Commandments. Maybe some of you remember the controversy, especially the one involving the big Texas monument there in front of the state capitol in Austin. 2 cases heard together, decided the same day. And again, if you didn't know much about constitutional law, you probably look at this Ten Commandments monument here, and this posted Ten Commandments that appeared on a courthouse in Kentucky, next to a bunch of other documents, including Declaration of Independence and Bill of Rights and different things. You say, well, if one's a violation, the other one probably is too, or vice versa. And you'd be wrong. Because again, the court split 5-4, going different directions with respect to these 2 displays. Now, there's no plastic animals anywhere, So what's the difference? Well, in this case, I think it's not the 2 plastic animal rule, but it's the 2-ton rule. The monument in Texas, in front of the state capitol, put there by the Eagles decades before. How do you get that out of there? It's going to take a bulldozer, right? On the other hand, if you want to remove the 10 Commandments from the courthouse wall, which one's going to create the bigger spectacle? Which one's going to have the bigger PR pull? Right? And I think what happened in these 5-4 cases, that Justice Breyer, who turns out to be the swing vote in these 2 cases, going one way in one and one way the other, looked at that and said, this would be a PR disaster for the court to have this bulldozer come into the public grounds in front of the Capitol in Texas and kind of yank this thing out of the ground, and I'm not going to go there. It's not going to be helpful to the court as an institution to order that to happen. And so I'm going to distinguish the 2 situations, and he did. He said, it's not just the 10 Commandments there in front of the Capitol in Austin, but in fact there are 38 different monuments there, different statues, different people who are important in Texas history and the like. And so, overall it's just kind of an area where we sort of honor our roots, and people aren't going to look at that and take it as a proselytizing message or necessarily an endorsement of Christianity. And Texas itself didn't put it there. They just accepted this monument that the Eagles were putting up these monuments all over the country, and Texas took one and put it into the ground. And so therefore it's a little different than in a courthouse where they made a conscious decision, the judge did, essentially to put up the 10 Commandments in a prominent place on the wall, sort of reinforcing the religious message. So he distinguishes those 2 cases. And what you see in this area, right, I mean, these are all 5-4 cases. It's just one justice's sort of idiosyncratic approach or view of the case, the factual distinctions, which seem to be very slim in many of these cases, that causes them to go one way or the other.